Here he comes.
Okay, Josh, we couldn't start without you.
All right, we're ready to go? I'd like to call the Board for Licensing Contractors meeting to order. Start with a roll call to my left.
Bill Mason, Greenbrier.
Cindy DeBus, Knoxville.
Mark Broad, Knoxville.
Jerry Hayes, Paris.
Ronnie Tickle, Memphis.
Item on our agenda today is adopt the agenda. Everybody have an agenda in front of them?
Yes.
Corrections to our agenda? Approval?
Motion.
Is there a second?
Second.
All in favor say aye.
Aye.
Motion carries. First item on our agenda is to approve the hardship cases.
These have all been reviewed and approved by a board member.
Move to approve.
Second.
Any discussion? All in favor say aye.
Aye.
Any opposed? The hardships motion carries. Next item on the agenda is the board meeting transcript from the previous meeting. Corrections to it? Approve it?
Motion.
Second?
Second.
Discussion? All in favor say aye.
Aye.
Any opposed? That motion carries. Next on our agenda is the approval of waived licenses.
First, or the interviews first?
Aimed to be
Waived
easier.
because it was on the list first, but does it matter? Motion to approve the waived.
Move to approve with any notes by the individual board members.
Second?
Second.
Any discussion? All in favor say aye.
Aye.
Any opposed? Motion carries. Interviewed applicants. Any discussion on interviewed applicants?
I just need to go over the ones I did, I suppose. I'll do them as a group if it's all right. These are all home improvement applications. Number 7251, Alliance Restoration. His license expired. He did a couple of jobs after the license expired. There is some doubt. We went over it about whether or not we had the proper address to send him the renewal notice and whether that was our fault or not. So my recommendation is no penalty for that violation. On 7970, Martin Restoration, he had a felony, and yeah, he had a felony. He's off of probation, and I see no reason not to go ahead and approve his application. On number 7898, Wilcox Construction, he had some projects over 3,000 in a home improvement county. He should have had a license. He applied right away when he found out he needed one, recommended a $250 civil penalty. On 7951, Romero Roofing and Services, he had projects over $3,000 in Hamilton County, recommended a $250 civil penalty. On number 7956, Metro Construction Services of Goodlettsville. He had a felony, and he also had projects over 3,000. He's off of his felony some time ago. He's off of probation. Recommended a $250 civil penalty. On number 7946, A Plus Enterprises had projects over $3,000 in Knox County. Recommended a $250 civil penalty. On 7950, he did some work in Shelby County. He didn't bid projects over the limit, but what happened was after he did the projects, they ran over some, but not by a whole lot. And I wanted to just go ahead and approve him with a letter of warning for his file. So that's my recommendation on all of those home improvements. So move.
Second.
Second.
Any other discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Cindy?
Okay. Oh, I'm sorry.
Okay, you didn't have any interviews.
No, I did not.
Okay, sorry.
I was working, yes.
We'll come back to you in a minute.
Okay. Scratch that.
I've got two, Mr. I recommend 68338.
Discussion? All in favor, say aye.
Aye.
Any opposed? That motion carries.
Mr. Chairman, I have two. Movement. He got. For some reason, Shelby County, I don't know why they did what they did, but anyway, he did not know that he. For some reason, there was no state license. Hired. This gentleman. like to grant him his license and fine him $250.
Second.
Second.
Any discussion? All in favor, say aye.
Aye.
Any opposed? That motion carries. 3 interviews, Rise and Run Construction was a felony. It was marijuana when he was in college over 10 years ago. I'm recommending approval of him. Six HVAC was a cocaine. He served 9 years in jail, about 5 years probation. Third one is Superior Enterprises, applying for a residential small commercial. C, and upon his successful motion.
Second.
Any discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Next would be revisions. Need a motion to approve revisions. Discussion on revisions? All in favor, say aye.
Aye.
Any opposed? That motion carries.
Second.
Any discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. LLPs are next. There's one LLP. I recommend approval of that LLP. He's discussion. All in favor, say aye.
Aye.
Any opposed? That motion carries. Item is our legal report.
Okay, thank you. On the legal report, I'm just going to be reading, starting with residential. After meeting with the subcommittees, I'll just be reading the changes that the subcommittee approved. Number 15, case number 2014-01-4091 and 2, the board recommendation was okay with issuing a consent order with civil penalty in the amount of $2,500 for engaging in unlicensed activity in a county that requires a home improvement contractor's license with authorization for a formal hearing. Also, the board would like to write a letter to Shelby County inquiring as to why they are issuing permits to unlicensed persons. Next case is case number 16 on the legal report, number 2014-014671 and 2. The board's recommendation was to issue a consent order in the amount of $2,500 civil penalty for engaging in unlicensed activity for home improvement contracting in Davidson County with authorization for a formal hearing. Moving on now to commercial cases. On matter number 4, case number 2014-018231, the board recommended that this is a civil matter best resolved in a civil court and to close. On represented cases, matter number 7, which was case number 2014-003741 and 2, the board's decision was to issue a civil penalty, consent order with a civil penalty in the amount of $1,000 to respondent number 1, which was the church, and to close as to respondent number 2. I believe that concludes all the changes on the legal report. The rest of them will be made part of the minutes to this meeting.
For your written report?
Yes, sir.
Okay. Is there a motion for approval?
So moved.
Second.
Discussion. All in favor of the legal report, say aye.
Aye.
Any opposed? Motion carries. Bid opinion request.
This is a matter where the subcontractor wasn't properly licensed. He didn't have enough limit to cover bidding both the plumbing and HVAC, and 4 out of the 6 bidders listed him. And so I do have people from the state architect's office here as well that if you have questions, you can talk to them about it. But what they're needing to know is whether or not they're going to put the job back out for rebid, and they want to know whether or not these same general contractors or prime contractors can participate in rebidding.
Have a statement or?
I'm Peter Heimbach, State Architect. What we're seeking clarification on is in 62.6.120 under penalties in paragraph 2. It states that, first of all, any person, firm, or corporation that engages or offers to engage in contracting without a license as required by 62.6.103 may, in the discretion of the board, be deemed ineligible to receive a license until 6 months after such date the person, firm, or corporation engaged or offering engaged in contracting. Additionally, no such person, firm, or corporation shall be awarded any contract for the project upon which it is engaged in contracting without a license or permitted to participate in rebidding of the project. And what our question is does that prohibition of participating in rebidding the project pertain to the subcontractor that offered their bid in violation of their license to the general contractor, or does it pertain to the general contractor's that offered their bid to the state. Our initial thought was that it just pertained to the subcontractor, but also have understood that there have been decisions that have weighed both ways.
Made decisions in both situations.
Make a difference if the contractor knew or should have known that there was. Subcontractor represents himself to the contractor as licensed, then it seems like the contractor would be acting in good faith. If the contractor knew that he wasn't licensed and they had some kind of deal like, well, you go ahead and bid and then get your license, then that would be a different deal.
In this case, there's a mitigating circumstance in that the subcontractor bid on two separate trades that they're licensed for, and they thought that they could submit two separate bids to the general contractor, both bids individually for plumbing, mechanical, and separately for electrical were underneath their licensing limit, but the aggregate of the two exceeded their licensing limit. And so according to what I've been told from through the Board of Regents, the contractor or the subcontractor thought that they could do that, and we've advised the Board of Regents that that wasn't the case, that the statute specifically prohibits subdividing bids in order to avoid a limit, and so that would be considered that. But the subcontractor also submitted bids to multiple generals, and out of the 6 general contractors that were on this project, 5 of them received bids from this subcontractor, and 4 of them received bids from the subcontractor in both trades, and listed them on their envelope as being the subcontractor selected.
State would like to rebid the project, and the question is whether the generals that listed plumbing and HVAC contractor, should they be allowed to rebid it?
I think we are of the opinion that the subcontractor should not be allowed to rebid it. The question is whether or not the statute, in the board's opinion, also precludes the 4 general contractors that listed them in both trades are also excluded.
Contractor thought that it was okay for them to separate the 2 functions.
The subcontractor thought that it was
But
okay
the
to separate
contractor
the 2.
did not.
I don't know if the contractor thought they did or not. The contractor, I believe, all 4 contractors, I believe, accepted the sub bids in good faith. I do not believe that they checked into it until after the bidding. I don't know that for a fact, though.
The subcontractor did have an unlimited monetary limit up until April 2014, so that was one issue as well, as several of the general contractors still thought their limit was unlimited.
When did it,
Just their license limit on the envelope?
No, it's not required to be listed. It was lowered in April 2014,
when did he,
October 29th.
We're
so just
October
wait.
29th.
Got 5 bids for the work,
Got 6 bids for the work.
and if we rule the contractors are disqualified, we rule out 4 contractors?
4 of the 6 contractors, yes. We don't believe, we didn't do any exhaustive investigation into it, but we don't believe that the general contractors proceeded with any intent or malice. Especially since there were 4 of them that did it this way.
in the past, you all have ruled that the general couldn't rebid, but it has been, like you said, just different cases. I don't believe we've had one quite like this one before.
I haven't had a real opportunity to research this issue, so I'm not, at this point, I mean, I'm still kind of, I'd have to look at it a little bit. If the board would like a legal memorandum on this, I could provide that to you in short order in the
Let's
next
look at
week
the-
or so, but
Let's look at the language of the law that we've got bolded on our thing. In paragraph 2 here, no person, firm, or corporation shall be awarded a contract for the project upon which it engaged in contracting without a license. Well, that doesn't apply to the general contractor, it seems to me. It applies to the subcontractor. And then it says, any person, firm, or corporation that accepts a bid in excess of $25,000 from a contractor who is not licensed. Well, again, that's not the case, is it? With appropriate classifications and sufficient monetary limitations. Why? Because of the subcontractors commits a misdemeanor. But have to obey the law. I'm not sure that the contractor was guilty of the violation rather than the subcontractor. I think we have to have a legal opinion.
I think the intent of the law is to prevent contractors opposing everybody else's bid and getting some sort of advantage. To some extent, that's occurred, but more of them that did it.
If I may, the other thing that we noticed in reading through the statute is that with respect to paragraph A2, it talks about any person, firm, or corporation that engages or offers to engage. And the word offers seems to point to the entity making the offer, not the entity receiving the offer. So the subcontractor by that is the one that offered to engage. The general contractor offered to engage the state, but they did it within their license limit. The subcontractor offered to engage in a contract with the general contractor in violation of their license limit. And so that's where we felt that the punishment from A2 should, meaning the preclusion from rebidding, should solely apply to the subcontractor. To your point, in paragraph B, the classification or the commission of a Class A misdemeanor may or may not, we hadn't looked into that, apply to the general contractor for accepting that if it was in violation of the limit. But that paragraph doesn't talk about preclusion and rebidding, only paragraph A2 does.
But, to go to a different way of looking at it, though, when the contractor submitted their bid, including that subcontractor's bid, and having accepted it, then they have submitted a bid that wasn't in compliance. So is it the contractor's job to do due diligence and make sure it's done right? And so that, if that's the case, then that flies against the theory that it's only the subcontractor that's made the violation.
The only thing that I would offer in to that point is that in paragraph A2 it points specifically to 62.6.103, and that is not where the requirements for the listing of subcontractors on the outside of the envelope is discussed in the statute. And so I would agree that the general contractor has some diligence and may have violated that diligence. I don't believe they've violated the license requirements in 626103.
Got taking a Board of Regents product here.
Pardon?
Project, is this a Board of Regents project?
This is a Board of Regents project.
And you're wanting to start construction when?
I'm not sure exactly when their start construction is. This is for a physician's facility in Kingsport, part of the East Tennessee State University campus.
6 bids before. If we rule out 4 of these and you're down to 2 bids, but you reopen it, I assume there could be other bidders then again.
Correct. It would be re-advertised in a new public bid, so there could be possibility of additional bidders.
Even if the subcontractors are ruled out of order, you're going to have to rebid it, aren't you?
We're going to have to rebid this no matter what we do, because the first bidder that was qualified without this subcontractor is above the bid target of the state, and so we're going to need to rebid it by our own rules.
Is the Board of Regents in the state under significant hardship if we postpone this to the next meeting and get a legal opinion about this?
Probably, yes.
But then at the same time, we want to do the right thing.
I think it was up to the contractor, the main contractor. And I'm not saying those.
And I would agree that the contractors that did list Cox did wrong. It's just the question of the punishment and whether or not the punishment of exclusion from rebidding pertains to those contractors or just to the subcontractor.
Both the contractor and the subcontractor, that's my opinion, I'm not an attorney. But based on what Bill has read,
We really don't, because there's another issue with one of the other bidders.
Well, I think, Ronnie, I think you're right. I think that the due diligence was the responsibility of the contractor, that when it was submitted, that they've submitted a bid that was out of compliance and over the limit because they didn't do due diligence checking out their subcontractor.
And they pointed out in their review, or in their response to our questions, that the bid came in, and I know this doesn't always make a decision, but their bid came in across the fax machine at 1:53, and it was a 2 p.m. bid deadline. And I know that happens all the time with bids. We all know it happens all the time with bids. But the question I would think in that case would be a practical one about whether or not you had the time to do the diligence. And if we were able to accept the second bid, then we would simply have kicked out the first low bidder and taken the second bid in that case.
hours to get his bids together. I believe he had more than any 2 hours.
Well, you know you're gonna receive a bid from Cox, you just don't have the bid yet. I think in the strictest interpretation,
Well, I don't think the state is necessarily handicapped from getting their project done. We're tasked with obeying the law as written. And in my opinion, the law written would disqualify the 4 contractors and forbid them to rebid the project. I move that that be the opinion of the board.
Need to amend it to be 5 contractors that can't rebid.
Was it 5 that submitted?
There were,
We only told about 4.
there are 5 contractors that used this subcontractor on their envelope. 4 of them used them in 2 trades.
Okay.
And so the 4 of them would be in excess, in the combination of the 2 sub bids that they put in excess of their limit.
Fifth
The
one.
5th one only listed them in 1 trade, and so they did not exceed their license limit.
Correct?
Correct.
So they're in, so we still got 2.
No, but the 5th one listed 2 people as the masonry.
That's not what he's brought to us.
Well, I mean, if you're gonna rule on how many rebids,
We're not sure the circumstances of the masonry bid. Carolyn just asked us that question in the last day or 2. We're not sure what the limit of or what the value of the masonry is or would be.
Have we been asked about the masonry today or just about the ones we've been talking about?
we were just asked about whether or not these contractors can rebid.
I would say we have to deal with what we're asking about. Masonry comes up, then we'll have to deal on the masonry. I think this is the main thing to deal.
What about the subcontractor? I mean, are they gonna be allowed to rebid because they knew that they were? Okay, just want to clarify.
That's not what we're asking about either. We're asking about, my
Yeah.
motion went to the contractor, the general contractors that submitted an incorrect bid because of this issue that we've been asked about. On the 5th bid, the contractor did not submit an incorrect bid. 6th bid, apparently there's no problem at all. So, I think my motion stays where it was with the 4 contractors involved.
I think that other motion based on the subcontractor, but right now we're dealing with the
Well, and I think from the state's perspective, we would preclude the subcontractor for bidding because we clearly think that subcontractor is in violation of the law.
Their intention to rebid.
And so we're not asking, I don't think, you're welcome to give an opinion on it, but we're not asking
That's fine.
your opinion on that because
That's
we
fine.
think that's
Their
clear.
intention to rebid under any
Yes.
circumstance.
We are going to rebid this project under any circumstance. We just need to know the provisions of that rebid.
Any other discussion? Should we do it?
Bill Mason,
Yes.
Cindy DeBusk, Jerry Hayes,
Yes.
Ronnie Tickle,
Yes.
and Mark Brudd. Okay. 5, yes.
Thank you very much. We'll inform the board and the contractors, the Board of Regents and the contractors. Appreciate your time.
Budget update, Carolyn?
Didn't get these in your iPad, but I'll pass these out. These are our, the last numbers of the fiscal year that come in. And it just shows what, our cost specs were, charges for investigations, and, there is a new expense this year, and it's called, on the next to the last line on the first page, the core expense. And so each division is having to spend money on the changes to the new computer system. So That's what the expense is there. But based on all the revenue, we currently have a balance, a reserve balance of 4.9 million. So that's where we're at right now after all the cost backs. Also, the Deputy Commissioner, Bill Giannini, he plans to meet with you all in January to discuss it more because he can answer a whole lot more questions about expenditures and things like that. Oh, I did this, the 3.5 million plus the 273,000 on page 2. And then the 1.1 million on page 3 for the LLEs. Our revenue is split up into different cost centers. No, it's just for your information, yes. Was this on the legal report, the formal hearing? I think it was listed in the represent.
His case,
Yes.
yeah, that was on the represents. And, yeah. The recommendation was $1,000 consent order.
We'll leave one formal hearing tomorrow, and it's going to be at 9 in the same room. And we're not going to have a quorum, a physical quorum, but we're going to have 2 members to participate by phone. So that's going to allow us to move ahead with the formal hearing. 5. Indy.
Adjourned. 9:25 on November 19th, 2014. This is Chairman Brudd, Chairman of the Board of Licensing Contractors of the State of Tennessee's Department of Commerce and Insurance. This time I would like to establish a quorum and do a roll call.
Ronnie Tickle,
Here.
Reese Smith,
Here.
Bill Mason,
Here.
Cindy DeBusk. Here. Ernest Owens. Here. And Mark Brudd.
Here. For the record, we need to determine if there are any other members participating by telephone. If you will, please state your name. I guess we've already done that, correct? Ernest and Cindy are by telephone. To TCA 8-44-108, which states that when a physical quorum is not present at the location of a meeting of a governing body, then in order for a quorum of members to participate by electronic or other means of communication, the governing body must make a determination that necessity exists. It must be included with a recitation of facts and circumstances on which the statement of necessity was based and be included in the minutes of the meeting. Thereafter, participation by a quorum of members will be allowed by electronic means of communication. All voting will be conducted by roll call vote. The sole purpose of this formal hearing requires the board to provide the licensee an opportunity for a hearing to allow the licensee due process and appear before the board concerning the evidence and defense in his docket. At this time, a motion is needed.
It is necessary, it is a necessity for the board to meet to offer due process to the respondent contractor.
Is there a second?
Second.
All in favor, say aye.
Aye.
Carolyn, I think you have to do a roll call vote.
Barney Tickle,
Yes.
Reese Smith,
Yes.
Bill Mason,
Yes.
Cindy DeBusk. Yes. Ernest Owens.
Yes.
Mark Rudd.
Yes. I will now allow Shalina Brown, attorney for the Department of Commerce and Insurance, to address the panel.
Morning, Chairman and board members. My name is Shalina Brown. I'm here on behalf of the Department of Commerce and Insurance, and I will now turn it over to the administrative law judge in this matter, Judge Begley.
Morning, everyone. I'll go ahead and get us started, get us on the record with regard to this docket. Today is November 19th, 2014. This hearing is convened before the Tennessee Board for Licensing Contractors to consider the matter of Hayes Heron Construction. The docket number in this case is 1214-126516J. As has been mentioned, I'm Michael Begley. I'm the administrative law judge. It's been assigned by the Secretary of State to preside over this matter. In that role, I won't participate in the decision on the merits, as you're aware. That's what you all will be doing. I will be here to make rulings on evidence, law, all those types of things, and under the authority that's been granted to me under the Administrative Procedures Act. All already been introduced, so I will state that I'm present on behalf of the state, as Commissioner Brudd has already mentioned, is Ms. Shalani Brown. Is Mr. Hayes Heron or anyone from Hayes Heron Construction present this morning? Ms. Brown, are you aware of anyone who was en route, stuck in traffic? Has your office received any confirmation that there was a problem this morning or anything of that nature?
Your Honor, we have not.
That being the case, before we proceed any further, Ms. Brown, do you have a motion?
Sir, I would like to move for default in this matter. The state has served the respondent with the notice of hearing and charges in this matter that was filed on July 31st and sent to the respondent by certified mail. Receipt number 701210000323814818, and I do have a signed green card receipt for the notice of hearing and charges by Hayes Heron Construction.
Do you mind passing that up if possible?
Sure.
For the record, it appears we have enough copies. I'm going to pass them to the members of the board that are present, if that's okay.
Sure.
Just one moment to have a look at this, and then. Okay, members of the board, pursuant to the statements made by Ms. Brown, as well as the certified mail receipt that was delivered to the address of record, that being 660 Waller Lane, Bolivar, 38008, was signed by, appears to be Vera Heron. Again, that date of delivery is cited on this document as August the 4th, 2014. I find that there's adequate service in this matter. That means, for your purposes, that legally speaking, there was adequate service and a default would be appropriate from a legal sense. The ultimate decision is still up to the board as to whether or not that's how you'd like to proceed. So I'll leave that to you now with regard to the default. Okay, could I get on the record the members who are voting on this and what your vote is, please?
I move to proceed with the case.
Second.
Ronnie Tickle,
Aye.
Reese Smith,
Yes.
Bill Mason,
Yes.
Busk, Cindy. Yes. Ernest Owens. Yes. And Mark Brewer.
Yes.
Thank you. Okay, that will be a default in this matter. Let me address a brief bit more before Ms. Brown puts on the proof that she's still required to put on. As you are aware, most likely this hearing is subject to the Open Meetings Act. That means that it must comply with the Sunshine Law, meaning all discussions, deliberations, they have to be on the record. So you sit essentially as a jury, and you'll consider the evidence that will be introduced and placed on the record. Please don't discuss anything with each other or anyone else if we should take a break or during the hearing. If the failure to comply with that could result in the decision being reversed after the fact. Also, before we proceed any further, has anyone, either on the phone or in this room, had any ex parte communications with anyone from Hayes Heron Construction or anything other than just notification of the hearing date? Has anyone had any communications about this case prior to now? Is everyone that I'm seeing saying that you have not? The two individuals on the phone?
I have not. Ernest Owens, I have not.
Thank you very much. If we should proceed and something should pop into your mind during the hearing, just stop us and we'll take care of it at that time, okay? This matter involves a disciplinary charge against the license, so that means the burden of proof is on the state this morning. They are the petitioner. That means they're the party seeking to change the present state of the affairs, in this case, the license. They have to prove by preponderance of the evidence that their case is valid. Essentially, that means more likely than not to you. You are the judges. You decide on the credibility of the witnesses you're going to hear this morning. Do not take anything that I say to mean that I have an opinion, yay or nay. It is entirely up to you based on what you hear from the people this morning. With that said, for now, I believe we are ready to get started. Ms. Brown, if I've forgotten something, please let me know, but I believe we're ready to go.
Your Honor, I don't know, at some point before I start, maybe I should hand out the notice of hearing and charges and give the board members a few minutes to look it over.
Sure. If you'd like to publish the charges, you may do that at this time. Ms. Brown, while they are reading, would you like to make the certified mail receipt an exhibit to this case?
Yes, I would.
Okay, we'll mark that as Exhibit 1. That's the one-page document that contains the certified mail receipt.
Ready?
Okay, we're ready.
Seeing as everyone's had the opportunity to review the documentations, let me also remind you that briefly of the procedure. Ms. Brown's going to call our witnesses. When she's finished, members of the board will have the opportunity to ask our witnesses any questions you may have of her. I also need to go over the technical record in this case very briefly. That's just the documentation that I have in my file that's been received during the course of this case. We'll start with the notice of hearing and charges, which the board members just read. That was received in our office, July the 31st, 2014. I also have one additional document, which is a notice of witnesses and exhibits, also by the department, received in our office, November 12th, 2014. And then I have a notice of intent to introduce affidavit filed in our office on September the 11th, 2014. That's also filed by Ms. Brown and the department. Is there anything else that needs to be a part of the technical record that I've left out? Okay, we'll enter that as a technical record. And let me swear any witnesses that we may have at this time, and if there's somebody that's not in the room and I forget, please remind me at that time. Who will be a witness? Do you solemnly swear the testimony you're going to give today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
And would you please state your name for the record?
Carolyn Lazenby.
Thank you, ma'am. Are there be any other witnesses?
No, sir. If I may do an opening statement.
Yes. At this time, I believe that's where we're at. Yes. Please proceed, Ms. Brown.
Good morning, Chairman, board members, and Your Honor. My name is Shalina Brown, and I represent the State of Tennessee Department of Commerce and Insurance against the respondent, Hayes Heron. This is a case about a contractor in Bolivar, Tennessee, licensed since 1991, holding a BCA license with a $300,000 limit and an expiration date of September 30th, 2017. He has renewed his license in 2011 and 2013 and submitted a falsified certificate of liability insurance in violation of state law in 2011. In October 2011, the respondent, Hayes Heron, submitted a renewal application with a falsified certificate of liability insurance. The department will present evidence through witness testimony that the respondent submitted this false certificate with his renewal application to the board. As such, this constitutes a violation of state law and grounds for revocation of his contractor's license. The respondent must be a licensed contractor in the state of Tennessee. The law clearly states the board may refuse to issue or renew a license to any person, firm, or corporation that submits false evidence with regard to an application of license or renewal. Board members, following the conclusion of the testimony and review of the evidence in this case, it will be very clear to you that the respondent, Hayes Heron, should have his BCA license revoked for engaging in dishonest conduct as a contractor. Thank you.
Thank you, Ms. Brown. Would you like to call your first witness?
Yes, Your Honor. My first witness is Carolyn Lazenby. Good morning, Ms. Lazenby. Could you please state your name and address for the record?
Yes, it's Carolyn Lazenby, and I'm at 500 James Robertson Parkway, Nashville, Tennessee, 37243.
And who is your employer?
State of Tennessee.
And what is your job title?
It's Executive Director.
How long have you been the executive director?
It'll be 10 years in January.
And what are your job responsibilities as the executive director?
Oversee the daily operations of the licensing programs, and this includes contractors, limited license electricians, home improvement, limited license plumbers.
And as executive director, are you the custodian of records?
Yes.
What are your primary job responsibilities as the custodian of records?
Maintain all the license files that are generated for licensing, as well as complaints.
And what do contractors' licensing files contain?
They include the initial contractor's license application, the renewal forms, any kind of revision application. And then also we have separate complaint files.
And who is required to be licensed as a contractor in the state of Tennessee?
5 contractors that perform work in excess of $25,000 or more. And also subcontractors that perform work, electrical, mechanical, HVAC, roofers, masonry.
And what are the requirements for someone to get licensed in the state of Tennessee as a contractor?
They're required to supply a completed application, and in it, it has questions where they disclose certain information regarding judgments, regarding any kind of discipline complaints. It also will have any kind of insurance that's required, the general liability and workers' comp for ones that have employees. It has a letter of reference. It has a financial statement to show that they are financially solvent.
And when a contractor needs to renew his license, what is submitted for the renewal?
Well, we asked some of the similar disclosure questions of whether they have complaints or have been disciplined by the board or outstanding judgments. We also ask that they supply proof of insurance for general liability and workers' compensation.
Are you familiar with Hayes Heron Construction?
Yes,
And what is Hayes Heron's status with the board? Are they a licensed contractor?
yes, they are licensed.
What is the license number for Hayes Heron?
29621.
How long has this contractor been licensed?
It's 9/27/1991.
How often are contractors required to renew their license? Did Hayes Heron renew its contractor license?
Yes,
And what is the most recent renewal of Hayes Heron's contractor license?
his 2013 renewal in April of 2014, and he has an expiration date of 9/30/2015.
Has there been any other renewal since then?
Prior to this renewal,
No, I'm sorry. Following this last renewal of 9/30, I believe you said 2015?
right, that's his last renewal.
Okay. And prior to that, did this contractor renew his license?
Yes.
When did he renew that license?
The license that expired on 9/30/2011, we received his renewal on October 27th, 2011.
And did you receive a renewal application from Hayes Heron in 2011?
Yes, we did.
Your Honor, may I approach?
Yes.
Mrs. Lazenby, do you recognize this document?
Yes.
Can you tell me what this document is?
This is a copy of his 2011 contractor's license renewal.
And is this document the type kept in the normal course of the board's business?
Yes.
Did the respondent submit a renewal fee with the renewal application?
Yeah, but he did not submit the late fee,
How much was the renewal fee
$100.
and the late fee?
The late fee, he owed $20.
And what else did the respondent submit with his renewal application?
Submitted a certificate of insurance.
And when was this entire renewal application package received by the department?
It was received on October 27th, 2011.
And who submitted the renewal application?
It was signed by Hayes Heron, owner.
What was his title, I'm sorry?
Owner, he listed owner. It's a sole proprietor.
And what is the license limitation?
300,000.
Did Hayes Heron provide the necessary information for the renewal?
It appeared that he had provided everything, but the certificate of insurance had some flaws to it.
By flaws, what exactly do you mean?
It was faded. It did not include the effective date in the upper right corner like they usually have. And so it just looked questionable. And anytime we see something like that, we want to confirm and make sure it's valid.
Was this brought to your attention?
Yes. The employee, when they reviewed the completed license renewal, they checked the Department of Labor's workers' comp website to verify the coverage on the license certificate, and it showed up that he was not covered. So that's when they brought it to me.
Thereafter, what did you do when it was brought to your attention?
I contacted the Department of Labor and spoke with the director there, and she also, her name was Kim Jefferson, she also confirmed that they were not covered.
And did you contact the insurance agent to
Yes.
verify?
I contacted the insurance agent by email on October 31st requesting whether or not the certificate was valid.
Your Honor, may I approach?
Yes, you may.
Lazenby, do you recognize this document?
Yes.
And could you please describe what this document is?
This is a copy of the email that I had received from the insurance company.
And what did you ask the insurance agent of this insurance company?
I asked them if they could confirm whether this was a valid certificate of insurance for Hayes Heron, and I provided them the address and explained that it was submitted as part of their contractor's license renewal.
And what did they respond with, and who responded to you?
I received a response from Bill Baxter, who is with the White Associates insurance producer, and his response was, no, we have not had him insured since 2007.
And on top, what exactly does it say in addition to that?
Where I forwarded it to our complaint coordinator, Talise Roberts, asking that contractor has forwarded certificate of insurance with renewal for her to open a complaint.
And after you received confirmation from the insurance company that this was a forged certificate, what action did your office take?
Opened a complaint and forwarded it to our legal division, and at the same time, we wrote the contractor a letter letting him know the deficiencies with his renewal.
Your Honor, may I approach the witness?
Yes, ma'am.
Lazenby, do you recognize this document?
Yes.
Could you please describe what this document is?
A copy of the letter that goes out to any license renewal applicant who needs additional information. And we mailed this out on October 31st, 2011, letting them know the deficiency that the board requested at $20 per month in late fee, and that the certificate of insurance could not be verified by the insurer, and for them to submit a valid certificate of general liability and workers' compensation insurance.
And did your office receive a response?
Yes, the contractor we have noted in our files called our office on December 14th, 2011, and stated that he would be sending the payments and the certificate of insurance.
And did you receive that certificate of insurance?
Yes, on January 4th, 2012, we received a certificate of insurance with an effective date of 12/28/2011, and also the late fee payment.
Your Honor, may I approach the witness?
You may.
Margaret.
Mrs. Lazenby, do you recognize this document?
Yes,
Could you please describe what this document is?
it's a certificate of insurance for Hayes Heron.
And who is the producer?
There is Jimmy Howe Insurance Agency.
And what is the policy effective date and policy expiration date?
Effective date is listed as 12/15/2011, and expires on 12/15/2012.
And is this the certificate of liability insurance that you received following a letter that was sent to Mr. Hayes Heron concerning his renewal application?
Yes,
And did your office or you receive a response or explanation from Mr. Hayes Heron about the previous insurance certificate that was falsified?
no.
Your Honor, I have nothing further.
Ms. Brown, would you like to make any of these documents exhibits?
Yes, I request that they be entered as the next consecutively marked exhibits.
So would you like for them to be separate in that would be 2, 3, 4, and 5?
Yes, please.
Okay, so for the record, we'll mark the notice of renewal, which is the only multi-page document, I believe a 3-page document, as Exhibit 2.
Right.
We will mark the email as Exhibit 3. We will mark the October 31st letter to Hayes Heron Construction about the late fees and the request for insurance. That'll be Exhibit 4. And Exhibit 5 will be the one we just passed out, which is the certificate of liability insurance. Okay, members of the board, any questions?
I have a couple of questions. How
Could
often?
you please, I'm sorry, please state your name for the
Bill
record.
Mason. How often are these licenses renewed?
Every 2 years.
So according to what the insurance, Mr. Baxter told you, he was not insured with their company since 2007.
Yes,
He renewed in 2009.
Yes,
Did he submit a false application then?
yes.
Why are we not hearing that case today?
I guess since we included that they had not been insured since 2007.
You contacted him, you said his insurance couldn't be verified. Did you question him further in any forum, by phone or in person or by letter, about what was going on with this falsified document?
We leave that to our attorney.
In the one you submitted that from Jimmy Howell Insurance, in which he got his most recent renewal, doesn't have a certificate holder listed on it. It's supposed to be the state of Tennessee or this board. Did you get an updated certificate? So we accepted this one even though it's not in proper form.
Yes.
Has any response to this charge been given to this board or that you know of? But, so since he was served with notice that he was being charged and he understands, we got the notice, we accepted that he was properly notified, they've not made any kind of response to that.
It's not.
Question, Carolyn, did you ever confirm with Jimmy Howell whether this
Our attorney did. Jeannie Taylor confirmed it, and then that's when she told us to renew the license, that we could not hold it.
she confirmed that it was valid?
Valid, yes.
Any other questions from members of the board? Okay, seeing none. Do you have any additional questions, Ms. Brown, based on those questions?
No, Your Honor.
Any further witnesses?
Your Honor, we did file a notice to have an affidavit entered in lieu of testimony of a Mr. Bill Baxter.
Yes.
If you wouldn't mind, I'd like to distribute that now to the board members.
Yes, go right ahead.
Your Honor, I would request that this be entered as the next marked exhibit.
It'll be so marked as Exhibit 6. Members of the board, I'll give you a moment to read over this affidavit. As this is submitted, it would be as though Mr. Baxter were testifying before us today. It's just on paper instead. Okay, any further proof, Ms. Brown?
No, Your Honor.
Okay, would you like to make a closing argument, or would you waive?
I would like to make a closing argument.
Go right ahead.
Chairman, members of the board, the facts are undisputed. Hayes Heron just does not care. It is very clear. He has forged insurance documents. He doesn't show up to formal hearings. He's ignored our communications, letters, and other documents from our office. The facts are straightforward in this case. It's very clear. This contractor submitted a falsified insurance certificate in October 2011 with his renewal application. He didn't just forge a recommendation letter or other document with his renewal application. He falsified a certificate of insurance for submission for renewal of his contractor's license. The respondent has ignored us. We know he has received all the documents. We know he has been served with the notice of hearing and charges, but he just thinks that this is going to go away if he continues to ignore us. We have no explanation for the falsified insurance certificate. He just submitted it to us and then submitted a replacement. Let's just think about this for a minute. If he can submit a forged document to the Board for Licensing Contractors, what else has he forged in the course of his business and conduct as a contractor? Who else has he conned and swindled? Is he taking advantage of the consumers of the state of Tennessee? The department has shown by preponderance of the evidence that the respondent has violated the law. As such, the department seeks a revocation of the respondent's license plus all investigatory and hearing costs as outlined in the notice of hearing and charges. Thank you.
Thank you, Ms. Brown. Okay, members of the board, you've heard the proof that's in this matter that's under consideration. It's my duty to now charge you as to the law that you have to follow in making your decision. You're the judges, the exclusive judges of the facts in this case, and also of the application of your rules and statutes to those facts. You must base your determination solely upon the evidence and the law that's been presented to you today. That consists of the oral testimony that you heard, as well as the documentary evidence that has been passed to you, which I believe consists of 6 different exhibits that have been marked. Statements made by counsel during the course of the proceedings are not to be considered as evidence, but simply as argument to convince you of their respective positions. Similarly, as I mentioned at the outset, do not infer anything that I say as opinion on either side of this matter. The Administrative Procedures Act requires your order to contain 4 things: findings of fact, conclusions of law, actually 3 things, I'm sorry, and policy reasons for your decisions. So when you're looking at your findings of fact, what we have to do is first make your own evaluation of the testimony given by each witness and give that testimony the weight and credibility that you believe is warranted. If there's conflict between the testimony, then it's your responsibility to reconcile that. At the end of it, it's your job to decide which witnesses have the most credibility over others. You'll have to believe everything each witness says. You can accept, reject, use your own judgment based on that. Once you've made your findings of fact, you must then decide whether the petitioner, the state in this case, has established a sufficient basis for the relief requested, in this case, revocation. Your conclusions of law should state the manner in which a statute or rule at issue applies, or if it's inapplicable to the facts. Your decision must also include sufficient analysis of the evidence to clearly demonstrate how the facts of the case support your conclusion. And lastly, the policy reason must also accompany your determination. Simply there is to state why the decision you render is appropriate for the general public at large. As we mentioned at the outset, your deliberations must be audible before the public, before all parties. It's inappropriate for the parties or their counsel to participate in these deliberations. I also will not participate. However, if you need assistance with the law or structuring of the order, I'm here to help with that. If you have any questions about the facts of the case, you may make a majority vote, reopen the proof, and hear from that witness again. So unless there are any questions about my charge, I'll turn the hearing over to Mr. Chair.
Excuse me, Your Honor, if you would allow me to submit the state's proposed findings of fact and conclusions of law.
Yes. Give the members a moment to read over that, if you like. Ms. Brown, did you want to make this an exhibit or not? Entirely up to you.
Yes, I would like to enter it as an exhibit.
We'll enter the proposed findings of fact and conclusions of law and proposed judgment by the state as exhibit, I believe, number 7 in this case. Chairman Brudd, when you feel like everyone's had the opportunity to read over that, you may proceed with deliberations.
Under deliberations, it's our responsibility to confirm the findings of fact.
That is correct. And for purposes of procedure, this document that you've just been handed is now an exhibit. That means you can read from that should you choose to guide. You do not have to. You can create your own. You can do whatever you like, but this document is an exhibit for your consideration now.
Chairman, for the benefit of our 2 members on the phone, I'd like to read into the record the proposed findings of fact. 1, the Department of Commerce and Insurance Division of Regulatory Boards, the state is the lawful agent through which the contractor's law is enforced, and the state is authorized to bring this action. Number 2, Respondent Hayes Herron, DBA Hayes Herron Construction, transacted and engaged in business as a contractor in Tennessee. Number 3, the respondent was first licensed in the state of Tennessee in 1991 and currently holds a BCA license with a $300,000 limit and an expiration date of September 30th, 2015. In October 2011, respondent submitted a renewal application including a falsified certificate of liability insurance. Number 5, the ACORD certificate submitted by the respondent with his renewal application was falsified. Number 6, Bill Baxter with White & Associates of Jackson, Tennessee, provided an affidavit stating neither he nor his company has, and I think that should be has insured the respondent since 2008 and did not provide the ACORD certificate for the respondent, and there is no record of a commercial general liability insurance policy for this coverage period within the company files. Company is insured. Chairman, it looks to me like this guy was not insured for 4 full years, all of 2008, 9, 10, and 11. Right. And that he, even though we didn't get the documentation on it except through the affidavit of Mr. Baxter, he obviously falsified his certificate again in 2009. And I think there's no question from the evidence I've seen that these findings of fact are applicable. And I don't know, see a whole lot, maybe question. I move that we accept the proposed findings of fact.
I second that.
Any other discussion? Roll call vote for the findings of fact.
Yes.
Reese Smith,
Yes.
Bill Mason.
Yes.
Busk,
Yes.
Ernest Owens,
Yes.
and Mark Brudd.
Yes. Motion carries, and the findings of fact as stated by Bill and in Exhibit 7 are.
That leaves us with the conclusions of law.
Mr. Chairman, with your permission, I'll do the same for the benefit of our members on phone. Proposed conclusions of law, respondents' acts and conduct in providing a falsified certificate of liability insurance that had not been issued since 2007 for a renewal application submitted in 2011 constitutes grounds for revocation of his contractor's license as issued by the board, as described in numbered paragraphs 1 through 6 of the foregoing findings of fact. This constitutes a violation of Tennessee Code annotated subjecting respondent to a possible civil penalty pursuant to the code in the maximum amount of $5,000 per incident and the assessment of investigatory and hearing costs pursuant to the code. And then Cindy and Ernest, they cite the actual wording of the law, which you are familiar with from previous hearings. And unless you need me to read it to you, I won't.
I'm good. I'm good.
Motion to accept the conclusions of law.
Motion.
And a second.
I second that.
Any other discussion? Carolyn?
Ronnie Tickle,
Yes.
Reese Smith,
Yes.
Bill Mason,
Yes.
Cindy DeBusk,
Yes.
Ernest Owens,
Yes.
Yes.
And we do need to have a short section before we get to the policy reasons, just the disposition section, the judgment, the decision that will ultimately be made by this board.
Did we find that we should fine him $5,000
That-
as a possible civil penalty?
That's correct. That is for the board's consideration, and that's where the board will address in this section what sort of penalty the board seeks
It was
to
under
impose.
conclusions of law.
Yes, that's the statute. As I understand, you're referring to page 3 of Exhibit 7. It states that that is the maximum amount. There is a proposed judgment on page 4, but as you mentioned, there are additional penalties that can be imposed under the law.
We can revoke the license. We can fine him up to $5,000 per offense. Can we do one for 2009 and 2011 both?
Per incident, so I would think so.
It's my understanding that's at the board's discretion, but I would say that if there is proof of both incidences, that would be something that you could do. I do recall, based on questioning earlier, that there may not be documentation of the second one in front of the board. There may have been testimony. If you'd like to call a witness back to get testimony in that second one, it's certainly within your prerogative to do so.
Well, I would suggest that I specifically asked Ms. Lazenby if he falsified it in 2009. She responded first. We have an affidavit from the insurance agent who said he was not licensed or didn't have insurance since January of 2007, which the necessary inference is, I think a positive conclusion is he didn't have insurance in 2009. The question is, do we want to revoke his license altogether? Is there a suspension option open to us?
My understanding, not being greatly familiar with the regulations in this matter, but for what the board has before it, and I'll just look over this for a moment. There's no language related to suspension in the proposed judgment. Let me read that section if you don't mind, I'm sorry. We're looking at section 62-6-118. This be subsection G. Simply states that it is within the board's prerogative to make, I'll quote it, the affirmative vote of a majority of the board is necessary to revoke or suspend a license or renewal. So certainly, that's within your purview to do either of the two. Please state your name again for the record.
Lazenby, he has 2 closed complaints.
For purposes of procedure, we do need to do a quick majority vote to recall Ms. Lazenby. So if you'd like to vote on recalling her to get that question on the record.
Can we just recall her for the duration of our discussion and ask her questions during that period?
You may, if you take a vote to do that, that's just fine.
Move to recall Ms. Lazenby for the duration of our discussion.
Second.
Roll call. Yes.
Yes.
Bill Mason?
Yes.
Yes.
So recalled, you may go ahead.
So he had 2 closed. Were they recent or it's been licensed since 91?
F rating?
His most recent renewal, Carolyn, does he have a valid certificate of insurance?
I'll tell you, you've heard me before on, lie to us, just lie to us. It gets my goat just worse than anything. It's a violation of, it's an affront to this state, it's an affront to the consumers. I think the closing statement goes to the heart of the matter. If he's not trustworthy, not only to turn in a valid certificate, but to even be insured. Frankly, I think the law is that they have to carry insurance. One of the findings of law we said was $1,000 a day penalty for every day you're out of violation. I mean, we theoretically, I think, find him $1,000 a day for all 4 years he wasn't insured, which I'll be impractical and never collected. But I have little patience with out-and-out dishonesty. If he'd come immediately after you found this and said, oh, threw himself on our mercy and pleaded whatever, you almost could see getting away with a fine, but like a pattern of dishonesty to me. I'm in favor of revoking his license.
I agree with you, Bill. If he cared about his business and wanted to continue in business, he'd be here today.
Well, I'd make a motion that we accept the proposed judgment, and in addition,
Second.
Any other discussion? Okay, Carolyn, please do a roll call vote.
Make sure we understand the motions to revoke his license and impose a $5,000 fine. Is that right, Rudy?
correct.
That's correct,
And
Ross.
number 2 says all investigatory and hearing costs. There you
Thank
go.
you. Thank you.
And for purposes of consistency, I don't believe this has been read into the record yet, the proposed judgment. If we were going to adopt that as it is written, if chairperson would like to read that into the record in its entirety.
That isn't what he just proposed, not, you said the proposed judgment plus a fine.
Correct.
I'll read into what his.
Whatever you'd
motion
like
is.
to be in the record, forgive me.
The proposed judgment is that the respondent is hereby revoked, and the respondent is assessed all investigatory and hearing costs incurred by the state herein pursuant to Tennessee Code annotated 56-1-311A. Tennessee comp and regulations for which execution shall. In addition to that, we are assessing a $5,000 penalty. So that's the motion.
And a second.
Ronnie Tickle,
Yes.
Yes.
Bill Mason,
Yes.
Cindy DeBusk. Yes. Ernest Owens,
Yes.
Yes.
And as I mentioned at the outset, the last section is the policy reasons for your decision.
Anybody want to take a stab at the policy reason?
Mr. Chairman, I would suggest that deliberate falsification of documentation to the state is a indication of bad faith with the public and with the customers, is a indication of poor business practices and dishonest dealings, and as such can't be tolerated by the board, and that the safety and welfare of the general public is best served by this individual no longer holding a license as a contractor.
Any other comments?
Yes, if you'd like to adopt what was just stated as that, you could do that.
Got that as our statement as needed.
Second.
Ronnie Tickle,
Yes.
Reese Smith,
Yes.
Bill Mason,
Yes.
Cindy DeBusk. Yes. Ernest Owens. Yes. And Mark Brudd.
Yes.
All right, thank you, everyone. That concludes this matter. Hayes Heron, and we are finished. Thanks.